Good afternoon, panelists. Good afternoon, delegates. My name is Tobena Erojikwe, and I'm the chairman of the board of the Institute of Continuing Legal Education of the MBA. I welcome you all to day 3 of the training on legal aspects of finance, overview, issues, and documentation. The training has been going on for 3 days, and I'm sure you all would have found the training very illuminating, the training so far very illuminating. Today, we'll be focusing on security interests and security documentation. And we'll be looking at different security interests that are created in financing transactions. So we'll be looking at share charges, all asset debentures, mortgages, and issues that relate to them generally. Also perfection and things like that. So I'm sure most of you would be interested to hear what the speaker today would have to say on those, on the topic. So today's speaker is Ejeme Ofoma. Ejeme is a senior associate with Olaniwa Ajayi LP's Power and Infrastructure team and is based in Lagos, Nigeria. She has significant experience advising sponsors, project developers, government institutions, development finance institutions, commercial banks, and other corporates on the development and financing of infrastructure projects with a particular focus on power, healthcare, and transport infrastructure. In 2018, Ejeme was selected as a Power Africa/Serious Urban Center for International Justice Fellow. And as part of her fellowship, she worked as an international associate with Oryx Energy, an infrastructure team in New York, advising on construction debt financings for renewable energy projects across the United States. Ejeme is a former foreign law clerk to Justice C.C. Virginia Kampeep of the Constitutional Court of South Africa, a Cornell Law graduate, a member of both the Nigerian and New York State bars, and has been ranked by IFLR 1000 as a Rising Star 2021 for project development. It's my pleasure this afternoon to introduce Ejeme. Ejeme, the floor is yours. Thank you.
Thanks a lot, Tobena, for that really kind introduction. As Tobena mentioned, a very insignificant part of my practice is really advising clients on financings of infrastructure projects. So I tend to deal a lot with secured financings. So today I really have the rather Herculean task of attempting to provide a decent overview of security interests and security documentation all in 1 hour. As many on the call I think would appreciate, there are many aspects of this presentation that are deserving of their own course. What I'll try to provide is what I consider a brief introductory practitioner's overview of the topic. Next slide. Broadly, my presentation will cover what security interests are, the forms of security interests. We'll dive into a number of security interests we typically find in Nigerian secured financing. And to clarify, when I say secured financing, I mean a financing that is supported by some kind of security package. We'll consider priority and perfection rules to the extent they relate to some of the security interests I've highlighted. I will also discuss the parties to a security document, as well as certain key provisions of the security agreement. Next slide. So, just in terms of terminology, I think it's useful to clarify what a security interest is. During this presentation, I will use the term security interest or security. And I prefer sometimes to use security interest, so it's very precise what I'm speaking about. But very simply, a security interest is a proprietary interest in an asset owned by someone else, which is held as security for the payment of the debt or performance of an obligation, such that after the repayment of the debt or performance or discharge of the obligation, the security interest ends. A key point to note in terms of terminology is that security interests are not securities. Securities tend to be bonds and shares, or essentially equity interests in companies or loan capital, so bonds and shares. Collateral sometimes is used to refer to security interest, but strictly are not exactly the same thing. Sometimes collateral is used to refer to contractual arrangements that do not necessarily qualify as security interest. An example is, for instance, margin collateral provided in relation to a hedging or derivative transaction. Then finally, I think we should all just keep in mind that possession is actually an indicia of property under common law. So that's why things like pledges and liens, which I will talk about in a bit, qualify as security interests. Next slide. So the security interests that you come across frequently in commercial practice in Nigeria include pledges, liens, mortgages, and charges. Mortgages in particular, and I think a good portion of this presentation will focus on mortgages and charges. You would also know that there are certain arrangements which are referred to as quasi-security that come up a lot in financing and security documentation. Some of them include retention of title, trusts, and sale and leaseback transactions. Just to clarify, it's useful to know what these things are because you definitely see them in a lot of provisions in security documents and in finance documents. So first, very quickly, trusts are essentially a legal fiction which involves splitting legal and equitable title. Sale and leaseback transactions, on the other hand, essentially is a contractual arrangement in which the owner of an asset transfers or sells an asset to a third party and then enters into a second contract with that third party to lease the asset for its use. While a retention of title clause is essentially a clause that allows the seller to retain legal and beneficial title to the goods until it is fully paid for those goods. So typically these provisions are often used in a lot of security documents. They are referenced in closing security documents, and it's very useful to understand what they mean and how they operate. Next slide. I'm just going to skip over pledges because they're not very commonly used in financing, Nigerian secure financings. But I think we'll just go straight to liens. These appear a lot in a lot of covenants in finance and security documents. A lien is a right to retain an asset, which is rightfully in that party's possession, but owned by another person until the claim of the party in possession is discharged. There are different kinds of liens, but I think the most popular lien in commercial practice in Nigeria is the unpaid seller's lien. Now, by virtue of the provisions of the Sale of Goods Act, an unpaid seller of goods, notwithstanding the fact that title has actually moved or passed to the buyer, has by implication of law a right to retain the goods for the price that is unpaid while it's still in possession of them. The lien allows the unpaid seller to essentially resell the goods after notifying the buyer of its intention to resell, and the buyer refusing to pay the price of the goods within a reasonable time. Next slide, please. We have mortgages. So next we have mortgages. Mortgages, you'll find mortgages a lot. I think mortgages and charges are probably the most predominant you come across in commercial practice. Mortgages, or a mortgage, is a security interest involving the conveyance of legal or equitable title to an asset and the reconveyance of that asset upon the discharge of the secured obligation. Over the course of this presentation, you hear me use the term secured obligation or secured liabilities. Now, what that means is typically you open a security agreement and you see these terms used, and what they used to refer to is the underlying obligation that security exists to protect. So, for instance, the debt owed by a borrower, which the security is meant to backstop or support. So, a number of key points on mortgages. A few of these are really will just be a bit of a refresher on what most people on the call would have done in law school or in university. First, we have the contractual right to redeem. Contractual right to redeem is the right to have title to the asset over which a mortgage has been created, reconveyed to the mortgagor if the debt is paid on an agreed date, by an agreed date. So typically, your finance documentation will reference certain dates or times when the underlying debt has to be paid. So your right to redeem the security when you've paid on that date is referred to as the contractual right to redeem. Second point is the equity of redemption. When a mortgage is created, the mortgagor retains an equitable estate known as an equity of redemption. If the mortgagor fails to repay the secured debt by the agreed date in the finance and security documents, the mortgagor nonetheless retains in equity a right to redeem the property until enforcement of the mortgage. So until the mortgagee chooses to enforce its security interest. Then finally, we have charges. Next slide. A charge is an equitable security interest that arises from an agreement to have a particular asset or groups of assets owned by a party appropriated to the satisfaction of the debt, such that the beneficiary of the security interest has a specifically enforceable right to look to the asset or the group of assets for the discharge of that debt. A charge does not involve the conveyance of title. That's why it's referred to as an encumbrance. All it means is that an asset is appropriated to the discharge of the specific obligation or the specific debt. Now we have two types of charges. Next slide. We have two types of charges, fixed charges and floating charges. Fixed charges are charges in which the relevant asset is immediately appropriated to the satisfaction of the debt, limiting the extent to which the charger, that's the grantor of the security, can utilize the asset in the ordinary course of its business. While on the other hand, a floating charge is an asset, is essentially a charge where the asset is not immediately appropriated to enforce, is not immediately appropriated to satisfaction of the debt. The appropriation process only occurs upon the occurrence of a future event. Now, the appropriation of that asset to the discharge of the debt is referred to as attachment. The future event that triggers the conversion of a floating charge to a fixed charge is referred to as crystallization. And I'll talk a bit more about crystallization in the next few minutes. Next slide, please. So as I said, crystallization is the process of converting a floating charge into a fixed charge. It's essentially the event that triggers attachment in respect of a subsisting floating charge. Under the provisions of CAMA, you will notice that sometimes when or at least you notice that when a floating charge is converted to a fixture, CAMA uses the term a floating equitable charge. You will note that provision, but the point really is that the character of the charge changes from a floating security to a fixed security. So generally, under common law and also by statute, crystallization automatically occurs when the debtor company is being wound up, when a receiver is appointed, when there's cessation of business. But parties also tend to, in security documents, also tend to extract undertakings that would allow a lender or the beneficiary of the security interest to trigger the crystallization of the floating charge by giving notice upon the occurrence of a specific event. Some of these events could include the creation of security, the creation of subsequent security or similar events. Also, sometimes you will see what clauses referred to as automatic crystallization clauses, where the lender, the beneficiary of the security interest, the security agreement will essentially provide that upon the occurrence of certain events, so that not other than the events contemplated under statute or common law, the floating charge will be converted to a fixed charge. These are known as automatic crystallization clauses, and there's quite a significant debate about whether automatic crystallization clauses are effective. And we can have a whole discussion about that in a single session. So just for you to note the existence of those kinds of clauses and to be able to recognize them when you open a security agreement. Next slide, please. So I'm just going to make a few points about priority and a few key reminders about priority, especially in relation to the security interests I've highlighted, charges and mortgages. Now, priority in simple terms is simply the rules that apply to the ranking of competing security interests. Priority is largely determined by the order of creation, unless a perfection rule impacts priority, say, for instance, Section 204 of CAMA, which I will discuss in a minute. Perfection does not generally guarantee priority, but an unperfected security interest will almost always be subordinated or displaced by competing interests in a company's winding up. In addition, generally, fixed charges have priority over floating charges over the same assets. Now, the exception largely lies in or rests in provisions of Section 204 and floating charges that benefit from the provisions of Section 204. In simple terms, Section 204 essentially says that a fixed charge on any property shall have priority over a floating charge, unless the terms on which a floating charge was granted prohibits the company from granting a later charge, having priority over that floating charge. This kind of provision is referred to as a negative pledge, and I will talk about negative pledges in subsequent slides. Now, under Section 204, the person in whose favor that later charge is created must have notice of that prohibition of the negative pledge at the time when the charge was created. In effect, under 204, where you have a subsequent fixed charge competing against a subsisting floating charge with a negative pledge, and the fixed charger, that's the subsequent fixed charger, had notice of the negative pledge at the time of creation of the fixed charge. So if it was registered at the CAC, then the fixed charge will not have priority. So this displaces, this perfection rule actually displaces the rules of priority, so the general rule on order of creation and the general rule on fixed charges taking priority over floating charges. Next slide, please. So 2 additional points on priority. Registrable security interest over certain special classes of assets, such as aircraft, that are not registered may actually not be afforded priority, even though more generally we think of registration as a perfection requirement. For example, under Schedule 6 of the Civil Aviation Act, a registered interest in aircraft or aircraft equipment has priority over any unregistered interest in the same equipment, even though the unregistered interest might have been created before the registered interest. So keep that in mind. And then for purposes of documentation and just for purposes of commercial practice, keep in mind that priority rules might be varied by contract. And this is essentially what subordination agreements are designed to achieve. Next slide, please. So quickly, perfection formalities. Now, perfection requirements and formalities usually depend on the nature of the assets, the nature of the security interest they're creating, the nature of the debtor's business. In relation to, say, movable property or immovable property and immovable property and movable property, you would normally have to stamp your security documents and pay applicable stamp duties. In relation to security interest granted over land, you obtain the consent of the relevant state governor and register the security agreement at the relevant lands registry. Note the requirement for registration of certain charges or certain registrable charges and mortgages under Section 222 of CAMA. Some of these are actually highlighted in the subsequent slides. So if you have a minute after the presentation, you can also have a look at that. One other thing to keep in mind is it doesn't really come up too much in secure finances in Nigeria, but just to keep in mind that there's a national collateral registry that in relation to movable property. So if that's an issue in your financing, keep in mind that there's actually a collateral registry. And that's created under Section 10(1) of the Secured Transaction in Movable Assets Act. Next slide, please. So moving very quickly, let's look at the parties to a security agreement. Typically, you would have the party that is the grantor of the security interest. This is a mortgagor, referred to as a mortgagor if a mortgage is created, or a charger if charges are created. Keep in mind also that, even though a security document might create security interests, including mortgages and charges and security assignments, you might define the grantor of the security interest generally as a charger. One of the other points to note is that the grantor of the security is not always the entity that owes the underlying obligation. So the borrower is not always the mortgagor or the charger. Secondly, you have the beneficiary of the security interest, usually referred to as the mortgagee or the chargee. In this respect, it's very commonplace in secured financings, especially in circumstances where syndicated facilities are either contemplated or are the underlying secured obligation, for lenders to appoint a security trustee or a security agent to hold the security interest for the benefit of the lenders and other parties entitled to benefit from the security. To clarify, syndicated facilities are essentially, or syndicated facilities or financings are financings where multiple lenders provide loans to a particular borrower under a single facility agreement. The security agent or security trustee is typically appointed under a trust deed, but sometimes you see trust appointments appear in intercreditor agreements and other agreements in which the lenders are parties. And appointing a security trustee can be very useful in managing perfection costs. It's useful because a borrower with a changing pool of lenders will not have to grant fresh security and then pay additional perfection costs simply because a particular debt has been discharged or a new loan has been granted by a new lender. Next slide, please. So the typical security package you find in Nigerian secured financing would usually involve a security fixed and floating all asset security over the assets of a borrower entity. So in this case, the documentation attempts to create security interest over all of the assets of the borrower or the relevant charger, right? And usually this type of security document is referred to as a security deed or an all asset debenture. This is probably one of the most predominant security documents you come across. In financing involving an international element where the Nigerian entity's assets, all of the Nigerian entity's assets are being secured, you might see the document referred to as an onshore security deed. Point is, the document is designed to embody security interests that cover all or attempt to cover all of the assets of the borrower or charger. Then also you have share charges. Share charges tend to be standalone documentation because the grantor of the security under share charges are typically the shareholders of the borrower or the shareholders of the relevant charger. We'll talk a bit about some of the provisions you find in the share charge. Also, we have assignment of borrowers' receivables. This you might find in your all asset debenture security deed, or it could be a standalone security document. Then we have charges over the borrower's accounts, bank accounts. This again could appear in an all asset debenture security deed, or it could appear in a standalone document accounts charge. And then finally, for regulated entities that have a principal license that is critical to their operations, you might also a lender might also get security over those licenses, and these are usually referred to as license charges. License charges can also be embedded in your all asset debenture or security deed. A few supporting contractual structures to note include domiciliation of borrowers' receivables. Essentially, this is a contractual undertaking by a borrower to pay certain receivables into an account domiciled with the relevant lender or a relevant entity. And it's not strictly security, but it supports the security package the lender might be obtaining in relation to financing. We could also have personal and corporate guarantees. So the individual or corporate shareholders of a borrower may also be required to provide guarantees in support of the financing. And finally, negative pledges. Negative pledges are essentially undertakings not to grant or permit to subsist security over a relevant secured asset. I'll talk about those in the subsequent slide. Next slide, please. So this slide sort of just highlights the key provisions you typically find in the security documents. Obviously, this is stripped of all the boilerplate provisions you'd expect to see. So things like assignments, severability, counterpart execution, all of that doesn't appear here. But these are the core provisions you would see in a security document. And the first is the covenant to pay. I'll talk about that in subsequent slides. But really, what it is an undertaking to pay the underlying secured obligation or secured liability. Grant of security, which is the core of the security document. This is the provision that creates the security interest under a security agreement. We have dealings with secured assets. This clause essentially governs what a mortgagor or a charger can do in relation to secured assets while the security is subsisting. We have negative pledges, conversion or crystallization of floating charges, all of which I've discussed earlier. Undertakings of the charger. This covers essentially certain undertakings that the charger provides in relation to the security while the security is in place. We have powers of security trustee and enforcement. I'll go into detail about this particular clause, but I won't go further into appointment of receivers because, like I said, that whole area is simply just an area that can be discussed under in a separate course. But you obviously have provisions that provide for the appointment of receivers and administrators and their powers. Provisions that relate to how enforcement proceeds are applied, sometimes referred to as order of application of proceeds or application of proceeds. You have clauses relating that grant a power of attorney to the chargee. Essentially, power of attorney that can be utilized by the chargee when it comes time for enforcement. I'll describe this in further detail. We have provisions that afford protection to third parties. Essentially, these are provisions that confirm that upon enforcement of the security, the rights of a purchaser, of a third-party purchaser, is indivisible, or at least the charger does not have claims against that third party. And then finally, we have the release provision, which I'll talk about in detail later. But really, it's what the term implies: release of the security interest created under the relevant security agreement. Next slide, please. So the covenant to pay provision. Now, just a few key points as we go through the rest of the slides. I've provided sample clauses for each of the clauses that I'm going to discuss. I will not go through all of those clauses in detail. I will simply make a few points. If you are interested in further looking at focusing on those issues, you can have a look at the deck after the presentation, just to see how some of the points I make relates to how you go about drafting some of these provisions. The first point is on the covenant to pay clause. Like I said, it's an undertaking to pay the underlying secured obligation. A covenant to pay clause is useful because it's critical in determining when the lender may exercise its rights to enforce the relevant security interest or security interest created under a security agreement. It is often combined with a no set-off or a no set-off provision. Now, typically, this provision essentially says that the charger has to pay the secured liabilities or secured obligation, and in doing so, will not attempt to exercise any right of set-off, any tax withholding, deduction, or all of that when you pay the secured obligation. Now, it's also useful as lenders counsel to perhaps expand secured obligations and the operation of this clause to include any pre- and post-judgment interest applicable to overdue amounts in relation to the underlying obligation. It's not necessary always to put in the security document. You could very well have addressed this fully in your facility agreements or other financing agreements. And then depending on the leverage of the charger's counsel, a covenant to pay clause typically should not appear in third-party security. So where a third party is providing securities to support a borrower's debt, because really what that party is undertaking to provide is simply security, not necessarily to pay the underlying obligation. Next slide, please. So the next clause I will discuss is the grant of security clause. This is sometimes referred to as a charging clause. But what it is essentially the clause that creates the security interest. This page has a sample of a grant of security clause relating to the fixed charge. You will note that the security is expressed to be continuing security. I'll discuss what this means. The charger is expressed or stated to be granting the security with full title guarantee or as beneficial owner. I'll discuss that as well. The fixed charge is described as a first fixed charge. It attempts to cover or create security over real estate, receivables, license charges, goodwill, intellectual property, accounts of the relevant charger. Now, this is very typical of this is a typical provision you will find in an all asset debenture or a security deed. Next slide, please. So this is typical of an all asset debenture or a security deed. Next slide, please. Similarly, we have a sample clause for a floating charge. Same thing, it's expressed as continuing security, describes the charge as a first floating charge. And then one crucial point about the grant of security clause in relation to floating charges is that very often you would have what I like to call actually a residual floating charge. Essentially a floating charge that captures all other assets that have not been effectively charged or mortgaged or assigned under other grant of security provisions. Next slide. So key points, continuing security. The continuing security might appear in your grant of security provision, and it would also appear as a standalone provision. But the point of making that reference to the security being a continuing security or including a continuing security provision is to ensure that you have a provision that displaces any implication or suggestion that the security interest will be released if there's an intermediate payment or discharge of the secured obligation. So, for instance, if the borrower owes 50,000 naira, if on day 5 of the subsistence of the loan, the borrower repays 20,000 naira, we're trying to avoid the implication that the security is discharged at that point. Also, in relation to certain trade facilities, so overdraft facilities, for instance, where the borrower's accounts might actually become credit after the creation of the security, you want to make sure that the security remains in place for any subsequent drawdowns by the borrower. That's why this particular clause or this reference to continuing security is important. The next point is on implied title covenants. You would have noticed that in those clauses, there's a reference there to the chargee granting the security as a beneficial owner or with full title guarantee. Now, the reference to full title guarantee, or sometimes we say limited title guarantee, is actually a holdover of English law template security documents. And this term actually implies certain title covenants into a document by virtue of the provisions of the Law of Property Act in England. Now, for Nigerian security documents, it's something for everyone on the call to consider whether we really should be replacing that term with the term beneficial owner. Beneficial owner has a statutory definition under the second schedule of the PCL, the Property and Conveyancing Law, as well as Section 7 of the Conveyancing Act. And the use of that term really implies certain covenants as the title into your security documents. So something to consider, or possibly an alternative could be to use full title guarantee, but to define it specifically and import that definition, import those covenants in the statute into your security agreement. Also, you would have noticed that the charges are often described as first floating charges or first fixed charges. The first is simply language meant to signal priority, but it is not determinative of priority, right? Priorities are essentially determined by some of the priority rules I've already discussed. I discussed earlier. Next slide, please. One other point there is on the drafting approach. As I mentioned, you might want to include your residual floating charge to cover all of those assets that are not effectively charged on mortgage and other provisions. But a few points to note about assets of a particular class. Typically, the assets of a company subject to a floating charge will normally comprise assets that the borrower uses or often disposes in the ordinary course of business. Whether a charge over these kinds of assets, so things like book debts, receivables, bank accounts, is fixed or floating, regardless of what you call it, is really a matter of fact. And it depends on the ability of the borrower to be able to deal with the funds in question or the assets in question, and the lender's control over the ability of the borrower to deal with these assets while the security is subsisting. And typically, as lenders counsel, you want to introduce provisions that demonstrate that the lender has significant control over those assets if you are attempting to create a fixed charge over assets of this kind. So examples of some of these provisions include restrictions on withdrawals, payment of book debts into blocked accounts, and clauses of that nature. But really, as borrower's counsel, if you have significant leverage, you need to ask yourself questions and to ask whether it makes any sense to attempt to create fixed charges over assets such as receivables or book debts. A quick note on qualifying floating charges. If you had a look at the new CAMA, a qualifying floating charge is a charge that generally has floating charges over a substantial part of the assets of the debtor company. But for you to be able to take advantage of the ability to appoint an administrator out of court, you need to have, your security document needs to give you the powers to appoint a receiver, an administrator, or reference the relevant provisions of CAMA that relates to out-of-court appointments of administrators. So that's just something to note from a drafting standpoint. Next please. Next slide. The next slide really relates to security assignments. Next slide. So security assignments, grant of security clauses that are essentially security assignments, are used to create security interest over choices in action. Changes in actions are essentially personal rights that are incapable of physical possession. So your rights in relation to debt or receivables. Now, legal assignments require the assignment to be in writing, right? It has to be in writing on the hand of the relevant assignor. It requires express notice to be issued to the debtor, right, to the relevant counterparty. And this is why sometimes when you open a security agreement that purports to create security over the rights of a borrower under certain contracts or insurance policies, you'll see a requirement to issue a notice to that insurance provider or contract counterparty. It is essentially to ensure that the security assignment is a legal assignment, is effective at law. One crucial point is to ensure that your security assignment also incorporates a proviso for reassignment. I'll talk about this further in the slides on the release clause. Next slide, please. Then finally, the last, I think, grant of security clause, other than in relation to share charges, is the mortgage clause. Essentially, a mortgagee is creating, the mortgagor is creating a mortgage as beneficial owner. In that case, it implies all of the title components I referred to earlier. In the case of the clause before us, it's proposed to create a first priority legal mortgage. Now, keep in mind, and I think this is a refresher from law school, that your mortgage is usually created by assignment or subdemise. Typically, there are other rules relating to that, but typically you're either assigning or you're creating a subdemise in order to create a legal mortgage. And ultimately, your mortgage is always subject to the mortgagor's equity of redemption. Next slide, please. So with a share charge, like I said, a share charge creates security over the share capital or the shares of a borrower And typically, the grant of the security of the charger is the borrower's shareholder, individual or corporate shareholder. So a few key points to note: your grant of security clause in the share charge should attempt to not only cover the existing shares of the charger. It should try and cover proceeds of sale derived from the sale of those shares. It should cover any additional shares that may be issued to that charger. You should also attempt to cover certain derivative assets. So everything from the charger's right to receive dividends or any subsequent rights to receive bonus shares or things of that nature. But also keep in mind in your share charge, a critical part of the share charge is a provision that relates to the sort of deliverables that the charger must provide for the chargee to be able to enforce the security if it has to enforce the security. This includes things like undated resolutions, signed irrevocable proxies, signed CAC forms. We can have a whole debate about whether share charges can be effectively enforced without the support of the charger. But I think that's something we can really discuss for a whole day. But just to know that this is what you typically find or require of a charger on a share charge. Next slide, please. The next slide is dealings with secured assets. And this relates to floating charges. Essentially, it's a clause that confirms or affirms the charger's right to use and dispose of the assets subject to a floating charge in the ordinary course of business. The key part of this provision really is the reference to goods or assets being used in the ordinary course of business and the period within which the charger can use those assets freely. So typically it's drafted in a manner as to allow the charger to freely deal with the assets until an event of default occurs. And the use of the assets or the disposal of the asset has to be during the ordinary course of business. I'm going to talk about what that concept, ordinary course of business, means in a subsequent slide on negative pledges. Next slide, please. So the next clause to keep in that you will come across, and it's pretty critical, both in your financing documents, so your facility agreements, and in your security documents, is the negative pledge. Now, a negative pledge, as I mentioned earlier, prohibits the grant or permitting to subsist any security over the secured asset, right? And sometimes it's not just security, it's also quasi-security. As lenders counsel, you want to make sure that it extends to quasi-security and other interests that might jeopardize your position as a secured creditor. It should prohibit the disposal of the secured assets, obviously other than assets that are subject to a floating charge that are yet to crystallize, and as long as the disposal is occurring in the ordinary course of business. Keep in mind Section 204, which I've already described and I've discussed earlier. A subsequent fixed chargee is deemed to have notice of a negative pledge associated with a subsisting floating charge, whether a notice indicating the existence of that pledge is registered at the CAC. So keep that in mind. Also, I think there are a host of negative pledge exceptions you'll find in a finance document, so in a facility agreement. But in a security document, typically the negative pledge has two principal exceptions, right? One, disposal, creation of security with the prior consent of the lender. As borrower's counsel, if you think that this is a clause that's critical for your client, you might want to include consent qualifiers. For instance, requiring the lender to act to not unreasonably withhold its consent, or not to unreasonably condition or delay granting its consent in those circumstances. As lender's counsel, you might want to include an express undertaking or express requirement for the charger to get the third party security holder to execute a deed of subordination, to subordinate their security interest to your lender's security interest. And then ordinary course of business. So there's a bit of case law on what ordinary course of business means. In particular, I think in the case of Ashburner, BB, and Green Gas Power, this is an English case, but I think it provides a useful description of what the test really is for, or at least how to determine whether a transaction has occurred or occurs in the ordinary course of business. Now, in that case, and in the context of a floating charge, whether a disposal or other act occurs in the ordinary course of business is generally considered in a question or a mixed question of law and fact, right? As a matter of fact, as an objective observer, with knowledge of the company, its constitutional documents, and also a view of how it operates its business, would it consider that transaction, or would that observer consider the transaction to have occurred in the ordinary course of business? If that's the case, or at least if an objective observer views that transaction as being the ordinary course of business, then the second question is, when you go on to consider the interpretation of the actual document, the document creating the floating charge, do the parties still include provisions that suggest that they did not intend the transaction to be considered in the ordinary course of business? So these are the two questions you need to consider. So the second question is focused on really contractual interpretation. The first is really, what would an objective observer with knowledge of the business really think about that transaction? It's useful if you have the time to read the Ashburner BB case. There's also another case, Kosas and ICLE, that also covers this concept of ordinary course of business. Next slide, please. So this is a sample clause. You can just have a look when you have the time. Next slide. So the next clause is really what's sometimes referred to as the enforcement clause, sometimes referred to as the power of the chargee. What it does is really just identifies when the security interests become enforceable and how the security interest can be enforced. It's typically drafted in to allow the security interest to become enforceable upon the occurrence of an event of default. As borrower's counsel, you would want to insist that that event of default needs to be continuing, because there's always the likelihood that you could cure the default in the interim. Also, it's set out the specific enforcement rights that the charger has, or the kinds of enforcement action, that the chargee has, and the kinds of enforcement action that the chargee can take. And it may be also combined with certain provisions that are meant to support those enforcement powers. Some of them include provisions that help the chargee avoid certain obligations that would associated with being a mortgagee in possession, but also just designed to ensure that the lender can take action to protect the security interest when the security is in jeopardy. Next slide, please. So this is a sample clause. I will not go in detail into the document, but just some portions of the clause to focus on. You'll notice that in the second portion of the clause essentially says that the chargee, when the security becomes enforceable, will be entitled to take possession of the collateral, to assign any or all of the collateral, to collect, recover, compromise, and give a good discharge for any monies paid or due or payable in relation to the collateral. Next slide, please. and also to appoint the power to appoint a receiver. I think one crucial point I think to note in relation to this clause is that typically you would find, or at least as lenders counsel, you should include a sub-clause that provides, essentially that provides what's stated in subparagraph E on this slide. That for the purposes of all powers implied by statute, the secured obligations are deemed to have become due and payable on the date of this deed. This is useful because under the Conveyancing Act, for instance, Section 19 of the Conveyancing Act, a power of sale only arises when the underlying secured obligations are due and payable. So it's useful to put a provision like this. So it's very clear to all parties, and all parties understand or agree that the power of sale has essentially arisen at the time they execute this deed. Of course, there are other restrictions on when you can enforce the security under the document, but it's critical that for purposes of that provision, you have a power of sale that has arisen. Next slide. The next clause is really the power of attorney's clause. It really does what it's, as described, affords the chargee a power of the chargee as well as its receivers or receivers they appoint, a power of attorney granted by the charger, which in general allows the receiver or the chargee to, for instance, empowers it to execute documents on behalf of the charger. Really, it's what you need. It's just an extra cushion for the chargee in the event of enforcement or in circumstances when you know that you might not be able to get the support of the charger to either enforce your rights under the agreement or even to enforce the security. So it's, as stated on the slide, it's necessary as the chargee cannot guarantee that the charger will cooperate with it when it needs to take steps to either perfect and realize the security interest or when an event of default has occurred. And it's really, really useful when the chargee needs to enforce the security interest, because there are certain things, certain documentation, certain filings that you can't possibly get beforehand. And you need that power of attorney to be able to proceed with enforcement without the charger's support. A drafting tip for borrower's counsel or charger's counsel is to ensure that this power of attorney is not exercisable until an event of default has occurred. This gives you greater control over when that power of attorney can be utilized by the chargee. Next slide, please. Finally, we have the release clause. Like the clause, like the name implies, it's essentially the clause that talks about when the security is released or steps that the parties need to take to release the security. It's a provision that requires the chargee to take any steps necessary to release the assets subject to security interest created under the security document once the secured obligation or the secured liabilities have been paid or discharged. So this clause essentially affirms the equity of redemption. And one point to note is that typically in standard documentation, the chargee bears the cost of release. Sorry, the charger bears the cost of release of security interest. As I mentioned earlier, the proviso for reassignment is useful and it's critical to include in this clause because of especially when you have security assignments in the document. This is the clause that essentially ensures that an assignment isn't absolute, but rather it is clear that the assignment operates by way of security. Essentially, to make sure that your security document doesn't actually transfer the assets to the security trustee or the chargee. I think this should be the final slide. I know I went pretty fast because I was trying to cover quite a lot of material in a very short time. Please feel free to ask me any questions on the material. There are additional slides on pledges and retention of title clauses that might be useful to look at in your spare time. Thank you.
Thank you very much, Ejaman. Anyway, I'll speak to your presentation in a bit, but I'll invite Mabel now to oversee Q&A, and then I'll come back later.
I must say well done to you, Ejime. You've covered a whole lot in a very short time. A lot of the participants has expressed their appreciation. They want your slides. Some of them wanted it to go a little bit slower so that they could get the explanations that you were given.
My apologies.
The first question says, will the grounds contained in section 203 of CAMA give rise to automatic crystallization? Will additional notice be required for crystallization under that section?
Okay, so the way that section is worded, it appears that it's automatic crystallization. And to be honest, there's no reason why it shouldn't operate in that way, because those three events, winding up, cessation of business, appointment of a receiver, at that point, the debtor company is already in a position, is not really in a position to either pay or is already in a difficult position. I think, in my view, crystallization upon when those events occur is already pretty late in the process. But I think, based on my interpretation of that provision, the way it's worded, it applies or results in crystallization automatically.
Very well. Sorry, forgive my pronunciation. Would like to know if there are materials or textbooks that can aid further understanding of your presentation.
Yes, there are. There are several books. I could send a list after this call, after this presentation. There are quite a few books on security interest. There's a book I reference in the section on the definition of security interest, Clark and Kohler. I think it's called Principles of Property Law. That has a good chapter on security interest. There's one by Roy Good. I think it's Principles of Credit and Security, something to that effect. It's a very good book. I can send the title after the presentation. I also authored an INSOL questionnaire at the end of last year on secure transactions. And that has a good overview of security interest in Nigeria as well as enforcement. Quite a few of the things I couldn't cover in this presentation are covered in detail in that questionnaire.
Thank you. There's another one here from, it says, would like to know if negative pledge qualifies as an encumbrance on the borrower's assets.
If it qualifies as what?
The negative pledge qualifies as an encumbrance on the borrower's assets.
Oh, okay. So I think the way to think of negative pledges is that it's really a contractual undertaking. It's not a security interest. It doesn't purport to create security. It's a contractual undertaking that you will not create subsequent security, that you will not permit to subsist any security over the relevant asset. Really, an encumbrance really is the appropriation of an asset to a particular obligation. I don't think it constitutes an encumbrance. I'm sure there might be people that disagree. I just think it's a contractual undertaking that relates to what you can do in relation to a secured asset.
I totally agree with you, and just lend my 10 cents to that question. Oftentimes, when you're enforcing, you will find some senior lenders who would have gone after the assets, and you will have nothing left if you have a negative pledge. So it's always safer to take a security rather than a negative.
But just so you know, it happens. So you might see that in security documentation that you review, and a lender might come to you post or after entering into certain documentation and ask you or expect you to say that if negative pledge is security, it is not security. So please keep that in mind.
Thank you. Ibrahim says, on the issue of protection of third party, what is its aim? Is it to protect the third party from liabilities?
Well, to some extent it is, but I think it's more a provision. It's almost like extracting an undertaking from the charger that upon enforcement of the security interest, a third party purchaser or whoever the asset is assigned to takes free of any rights that the charger might have in the assets. That's what it's supposed to be. It's just to be a contractual undertaking from the charger, confirming that. I wouldn't say that it affords the third party any added rights, obviously because of privity issues. But it's really a question of providing comfort to third parties, especially third parties acquiring assets in an enforcement scenario.
Right. Would you be able to provide a bit of insight as to quasi-security? You skipped it totally. Please discuss your slides on this. This is from an anonymous attendee.
It's from a what?
An anonymous attendee.
Okay, so I tried to talk about quasi-security in the first portion of the slide. I skipped retention of title because of time constraints, but I did mention what qualifies as quasi-security. So things like trust, sale and leaseback transactions, retention of title clauses, those qualify as quasi-security. They are not security interests per se, but they might be utilized or used in a way that they create a similar effect. Retention of title clauses, as I said, are clauses that allow an unpaid seller to retain title in an asset until the buyer pays the relevant price. Sale and leaseback transaction is essentially a transaction where the owner of an asset sells the assets to a third party and immediately enters into a second contract to have that third party lease the asset back to the owner. And trust, of course, is the legal fiction of separating legal and equitable title in an asset.
Well, from Miriam, she says, where the borrower is different from the charger, can the security document be drafted to impose obligations on the borrowers too, in such a way that both the borrower and the charger can be defined as obligors?
Can be defined as what, sorry?
As the obligors.
Yes, it's possible. And I would say that in those circumstances, you would include the covenant to pay in the document. Of course, there's a debate about which of the obligors assumes that obligation, but it's definitely possible.
Freddie Kemi says, what will be the incentive for car lenders or charges to subordinate the security interest in a subordination agreement?
What would the incentive be? Well, it could be a number of things, but I think sometimes it's a senior chargee or senior creditor knowing that the business requires additional funding in order to be in a position to repay the senior debt. That's usually an incentive for permitting the creation of subordinated security. I think that's a critical one. If the secured lender is not if the senior lender knows that it's not in a position to provide further financing to the borrower, and the lender and senior lender is aware that the borrower requires additional financing in order to stay afloat and be in a position to repay the senior debts, then the senior lender might have an incentive to permit subsequent security, provided that it's subordinated.
This is interesting from Adebanji. He says, if a negative pledge is not a good security, pledge is not a good security, why do we have the legal stipulation of having it registered with CAC as a
if it's not security, it's really just not security. The reason why we need it registered or why it should appear as CAC, at least my 2 cents, I don't know what the original adjustment thought, but my 2 cents that the reason why you want it registered is because the section 204 operates to displace relevant priority rules. So, and this the common law priority rule on relation to fixed charges and floating charges is that if you create a fixed charge over an asset, whether you create it on day 1 or day 90, right, and day -1, you have a floating charge, that fixed charge will always take priority over the floating charge. That's just the way it works, because the floating charge defers appropriation of the assets with debt until crystallization. Now, 204 essentially displaces that rule. And for a fixed chargee who ordinarily just assumes because I have a fixed charge about the assets, I take priority over any other floating charge. Really, that kind of provision should be registered or should be available to be seen by other third parties who might deal with the charger. I think that's why it's registrable.
And I also think, if I'm correct, in most of the loan documentations, you find out that it's expressly stated as a supporting document. It wouldn't typically come under the heading securities.
Yeah, it is not security. Like I said, it's just an additional contractual undertaking in your security document.
An anonymous attendee has asked if we can say that the negative pledge clause tends to protect the lender.
The negative pledge, what, sorry?
Does the negative pledge clause protect the lender?
Yes, it does. It protects a lender who has been granted a floating charge.
It's based on the fact that
No, it protects a lender. Actually, it protects a lender in every instance. But I think in relation to 204, it protects a lender that has been granted a floating charge. But more generally, it protects a lender because you really don't want your borrower or your charger to dissipate the secured assets. Because as I mentioned during the presentation, a negative pledge prevents you from creating subsequent security, prevents you from disposing the assets while the security is subsisting, unless it's subject to a floating charge and it's a disposal in the ordinary course of business. So it really does protect a lender, and it's very useful and critical to include in the security agreements.
I think somebody wants me to make my voice more audible. Thank you, Ebenezer. But from my experience, I've represented a lender who wanted to enforce their securities, and all the securities they had, in a sense, was a negative pledge. We had a tough time because there were other secured lenders in place, and it resolved by entering an arrangement with the customer of the bank. So we really had a difficult time relying on that negative pledge. We couldn't go after them. If we went to court and we tried winding up, other senior lenders will take priority over our interest. So it's a difficult position you want to take as a lender.
So I think that example is exactly why you should not rely solely on a negative pledge. Create a security interest. A negative pledge is just additional protection. In most security documents, I think if you open most facility agreements, a negative pledge may operate if, a negative pledge really is just an undertaking. You can sue for damages for breach. It's not a security interest that you can enforce. Sometimes it might operate as a draw stop, so you can't draw down on any additional facility, on any of the commitments that are left. But it's really not security. So always advise your lenders who are looking for security to actually create security and not rely on a negative pledge.
And I must say that we've had an interesting conversation. It's 3:00. I would imagine that we have another presentation after now. And at this point, I must yield to Brenda.
No, Mabel, do you still have other questions going?
We actually do.
Yeah, go ahead.
All right. Okay.
Yeah, I think we still have time. Is that not your understanding that you still have some more time?
Some more time. Sure, a few minutes more.
Are you tired already?
No, I'm good. I'm good. Some of the questions are actually thought-provoking. So, yeah.
Indeed. Thank you.
Right. So, Kingsley says, what is the position where a winding up petition is already filed and a secured creditor is pursuing to enforce his right over the assets?
So I think it depends on when the enforcement process started, but typically when there's a winding up petition, there's not much you can do at that point. But remember, if you have security, you are outside the pool, insolvency pool. You don't actually have to compete with other unsecured creditors. You have that asset to get repaid. So that's the critical point. If we go into a long discussion on winding up and the rules that apply, we're going to be here for days. But the point to note is that once you're secured and your security is valid, is fully perfected, you are outside the pool of unsecured creditors who have to compete for assets in the company's insolvency. That asset is essentially appropriated to payment of your debt.
Ramat says it would appear that regardless of what is contained in an agreement, recourse must be had to the court to interpret the document before there is enforcement. Is there no way around this? That's
not really my view. But yes, there are sometimes when, of course, a borrower or a charger can rush to court and say you don't have the right to enforce your security in this manner. That's always something that's likely to happen, regardless of what you put in your documentation. But yes, there are definitely instances where you can enforce your security without having to resort to the courts.
Where an investor lost his investment on account of regulators imposing obligation on the company, which she cannot meet, who will be legally responsible for the refund of the investor's funds?
I'm not really sure that's within the scope of the presentation. Investor, well, if at the end of the day, if the investor gave funding to the company, it's really the company that they can go after. But in terms of these kinds of investment, depending on the kind of project, sometimes you could have sponsor support provided in relation to, for instance, debt financing provided to a project company. And in that instance, you can go after the sponsors of the project company. But really, typically, it's the company that is on the hook.
I guess that's where the due diligence comes in if you're taking or you're investing your money. And like if it's NBIC or stuff, but what they really give you is very minimal. So the obligation is for the party investing to do it very well. Anonymous attendee says, is finance law all about loans?
Is what, sir?
Is finance law all about loans?
It's finance law all about loans? No. I think there was a presentation on Monday that really talked about what finance law is about, the various aspects of finance law. So it's not just about loans. It's also about equity. And I think there might be sessions that will cover equity capital. And I think thinking that it's only all about loans and debt is not the right way to proceed with it. Just think about it as how a company raises capital to operate. Now, this could take different forms, whether it's equity, whether it's debt, whether it's bonds, or just issuing shares. There are a lot of things that count as finance, so it's not just loans.
This is another one here. In most cases where the right of sale in a registered mortgage arises, the borrower refuses to transfer actual possession irrespective of the legal mortgage. What does one do in this?
Sorry, I didn't actually hear the question. All I heard was right to sell. Right of sale.
So she said, that isn't his question. She says, in most cases where the right of sale in a registered mortgage arises, the borrower refuses to transfer actual possession irrespective of the legal mortgage. What does one do in this case?
So you have a power of sale. You can actually sell. Might refuse to transfer possession. Then you might have to resort to the courts. There's not much you can do. But the point is the power of sale is definitely exercisable out of courts. There are other out-of-court enforcement options, but really a power of sale is exercisable out of courts. So you're really in a position to just execute documentation to enforce or to utilize your power of sale. If the mortgagor refuses to transfer possession or hand over possession, then you might have to resort to the courts.
What security documentations would you recommend to fully protect the rights of a lender with respect to syndicated loans with a company experiencing an economic downturn?
I don't know that it's a security documentation that would protect you in that instance. But I've talked about quite a few of the kinds of security documents you would normally see in secured finance in Nigeria, and those can be obtained dependent on the nature of the debtor company and the kinds of assets it has. I think is really a question. It's a commercial question. Is the lender really in a position to lend? If it's in a position to lend, what are the kinds of protections it needs to be able to do that? Whether that's security, whether that's deposits that you can see, whether it's proceeds that he expects to see in the future that will be used to repay debt. Those are the kinds of things that the lender will consider in order to provide financing. But ultimately, the security interests are really the same type of security interests you see. The all-asset security, which is the all-asset debenture or security deed, your share charges and the like.
And I would imagine the lender's question will be if there won't be a risk of default if they already experienced an economic downturn.
The prospect of default, of imminent default and insolvency, and that's really a credit risk that the lender has to assess.
Another question here from this anonymous attendee says, how many mezzanine investors covered inside the security document?
How many what, sorry? Investors are.
Is any investors covered inside security documents?
Well, if you have a group of lenders, a syndicate of lenders that includes mezzanine lenders, for instance, which is possible, in that case, really what would usually happen is that the chargee is a security trustee that holds security for all of those lenders. So you will not typically see all the lenders as parties to the security documents. It's their security trustee that would execute the document as charging.
There's a question here, but I don't think it came out of your presentation. What is the priority between security interest and judgment debts?
Yeah, it doesn't come out of my presentation, and it's not, priority rules only apply to security interests.
Falasha Day said, can the lender decide not to disburse at any time? Or are there any consequences of the lender's failure to disburse at the agreed timeline of the facility?
So if the borrower is not in default, the lender really should really disburse. But there are many circumstances where there can be a draw stop. And sorry, the term draw stop actually means the lender has a right to not disburse any part of the facility. There are many circumstances. If you are in breach of a covenant, of a negative or of a covenant or undertaking in the facility agreement or in the security document, the lender might actually have a right to draw stop, so not to disburse any part of the facility. And typically that would often lead to a default or an event of default. So those are the kinds of things that entitle the lender to draw stop. But typically, if there's no event of default, if the borrower is complying with his undertakings and obligations, the lender actually has an obligation based on the terms of the facility agreement to disburse the facility as and when agreed and when all the relevant condition precedents have been satisfied. But that's obviously outside the scope of this presentation. I think if you've had the session on loan agreements, that's probably something that might have been discussed during that session.
I think if it's a multi-currency loan, for instance, availability for our lenders here in Nigeria also determine whether or not the lender will. Most times,
when the lender might get out of having to disburse.
But most times, lenders insert clauses in the agreement that protects them when they do not default. It makes it more difficult for you to go after a lender for not disbursing. We have another one here. This is on AMCON. I don't recall you mentioning AMCON in your presentation. Would you like to take it? The role of AMCON in asset recovery.
Like I said, we can be here all day talking about that, talking about the AMCON receiver. But what I can do is direct that person to the person with the question to my ICLE survey. I talk extensively about AMCON receivership and how that compares to a receivership on the camera.
Another thank you for you here, HMF, from our audience. And the question here says, when does equity or redemption elapse? Equity of redemption elapse?
The equity of redemption elapses when the chargee or the beneficiary of the security has enforced the security. So after the due date for payment has passed, the contractual right to redeem has already passed. You retain the equity of redemption until the mortgagee or the chargee enforces the security.
As if a receiver manager starts selling assets based on interim rather than the final order, can the receiver manager start selling assets based on interim rather than the final order?
I think the person it's outside the scope of the presentation, but the person who asked the question should look at receivership generally. Receivers are sometimes typically appointed out of court. You might get a court order to support your position, but it's possible to appoint a receiver out of court. So in those circumstances, you don't need a court order to sell assets. But like being in a litigious society, you're likely to have a charger who would try and stop the receivership process by going to court. So that's obviously a relevant consideration. But also, I think that ICLE survey also covers receivership and the powers of the receiver. So just that covers it in detail, especially in the context of the provisions of CAMA 2020. So that's a useful document to just get a sense of the topic.
I think there's another one here. Can the negative pledge clause be waived? Secondly, are there repercussions where there is a breach of a negative clause?
So can it be waived? When I discussed negative pledges, you will note that I talked about exceptions to negative pledges, or say carve-outs to negative pledges. And typically your security document or your negative pledge clause would allow you to do the do the acts or actions that are prevented by a negative pledge if you get the consent of the lender, right? Also, you remember that the negative pledge precludes disposal of secured assets, except where the assets are covered by a floating charge that has not crystallized, and the disposal is occurring in the ordinary course of business. So that's a way to get out of the negative pledge, or at least a carve out that you can rely on. A negative pledge, like I mentioned earlier, and I keep saying it's simply a contractual undertaking. You enforce it like you enforce any other contractual provision.
I don't recall you, HMS, saying during your presentation that negative pledges are meant for blue chip companies. I'm wondering why this question arises. I don't recall you ever saying that negative pledges are for blue chip companies, but someone has asked you if negative pledges are only for blue chip companies.
No. And no, when I say companies, I just mean companies of whatever kind. I'm also talking about any specific kinds of companies, just companies.
Noki says, which is the proper authority where a security can be registered, SEC or CAC?
When I was discussing perfection, like I said, it depends on the kind of security you've created. The kind of security determines what you need to do to properly perfect it. Like on that slide, I talked about immovable property, certain specialized assets, and some of these have very different perfection requirements. Even some just creating security over the assets or the share capital or the shares of a company in a particular regulated sector might also require approval of the sector regulator. So it really just depends on the nature of the assets and the nature of the security you've created.
Would you be kind to provide a bit more clarification on license charge for EFINE?
I don't know what's additional. It's security over the charger's rights in its core license. And if you remember, license charges are charges that are created over the charges of companies in regulated sectors, where really the charge is a very critical part of the company's business, right? So for instance, if you're dealing with a distribution company, a generation company, its license, its NERC license is a critical part of its business. Without that license, it can't do much. And what a license does is essentially create security over whatever interests the charger has in that license. I don't know if the person has any specific question.
Thank you. Is there any practical relationship between purchase money security interest under the secured transactions in immovable assets 2017 and the floating charge under CAMA 2020?
The first part, I heard the second part of the question, but the first part of the question, I didn't hear. Purchase money security under what statute?
Is there any practical relationship between purchase money security interest that's under your secure transactions in Immovable Assets Act and the floating charge under CAMA?
Honestly, I've not really researched the STMA in detail, so I'm not really in a position to answer that question. It's not something I really deal with on a daily basis.
In respect of enforceability of a security document, which would be, or what would be the effect of an unregistered security document, which includes the provision of a negative pledge in terms of a mortgage or a child?
Unregistered security document. So 204 is clear. The floating charge benefits from 204 if the negative pledge is included in registration at CAMA. If it's not registered at CAC, if it's not registered, it doesn't benefit from 204. right? And sorry, if the fixed chargee, the subsequent fixed chargee doesn't have notice, that's the core requirement. If it does not have notice of the subsisting floating charge and the negative pledge associated with it, then it doesn't benefit from 204. 204 sort of says that if you have registered it at CAC, the subsequent fixed charge is deemed to have notice. So I think that's the distinction. Now, the real question about whether an unregistered charge where you have evidence that the subsequent fixed chargee knew about the existence of a negative pledge is a whole other debate. I'm not really sure how the court will come down on that. Because really 204, the proviso in 204 is just to show that CAC registration ascribes notice, or CAC registration means, or is the subsequent fixed charge is deemed to have notice once you register at CAC. Now, the question of if you can show actual notice, whether 204 will still apply, I don't know how it will go, but I think on the strict interpretation, it could possibly apply.
This is the general one. I don't know if it's something you'd like to speak to, and that is, what are the major finance documents to be executed in oil and gas lending?
Major finance, oil and gas lending. Honestly, I don't do that on a daily basis, but it's a general question. So what I try to do with that slide on your typical security package is to really highlight some of the things that you generally see on secure finances, whether that's in the oil and gas sector, whether it's in the power sector or any other sector. Those are the things you normally expect to see. You might see that the particular receivables that you assign by way of security might relate to receivables under your production contract, whatever contracts you execute as an oil and gas market participant. So, but the point is, the principles are really the same. It's the same kind of documentation, it's the same kind of security. It's just that the underlying assets will change from sector to sector and from company to company.
Khalili wants to know if a non-registered money lender lends money to someone with interest and there is a default, can he sue to recover interest, having not been registered as a lender, money lender?
A money lender, so someone who is registered, who has, I'm not even sure what. So if an individual lends money to somebody else, so someone who is in the registered lender, if you can go to court to sue for your funds.
I imagine he's speaking to money lenders that when you lend money and you're not authorized to do so, you're not a money lender.
But you know also that I could be, I think the question is the frequency of lending. Right? I think that's the core issue. But if as an individual you lend money, you're not a registered money lender. You're an individual, you simply just lend money to somebody. That's not your core business. So you don't trigger licensing requirements. Of course, you can sue for your funds. Okay, I think I might have to step out in a few minutes. So I can maybe answer one or two more questions.
Don't worry, I must
maybe we can close if we got to this point. Yeah?
Okay. I'll yield to you to bring that.
Okay, thank you very much. Ejemena, what a brilliant presentation. Well delivered to time too. Fantastic. And I was quite happy that you took the time to answer questions, even questions that are outside the scope of your presentation. Thank you very much. And I'm sure that insult survey that you referred to must be a good read. So I encourage everyone to sort of grab it and then cover up where you need to cover up. But thank you very much for a well-delivered paper presentation and for taking the time from your busy schedule to do this. I mean, it's quite remarkable because we don't offer honorarium for these things, but we're grateful that you're giving back to the profession. So thank you very much.
Thank you so much, Tobina. And I will share the insult survey and also the textbook I referred to earlier, just the names for any participants that are interested.
Thank you very much.
Thank you.
Then, generally, I noticed that there were quite a number of questions yesterday on the collateral registry and today again on the STMA. So we're going to have to take that up and probably get someone to present a paper on it so that we take that generally. And also, a lot of people have been asking about the slides. The slide for today's presentation and the slides for the other presentations will be sent out today at some point if it haven't already been sent out. But it was sent out through the MBA mailing lists. So thank you very much. Tomorrow we have two presentations. One is on, just a second. We have two very interesting presentations on understanding financial covenants and debt and equity capital markets. So for those who have been asking about whether financing has to do with only debt and loans, tomorrow is your opportunity, even though this would deal specifically with capital markets, so raising finance from the capital markets. And I encourage you to participate. It will be two sessions. We only had one session today. The other session that should have happened today would then be moved to Tuesday. So thank you very much for participating. Do please encourage your colleagues and friends to also participate in these trainings. And any feedback that you're able to give us, we encourage. So thank you very much and God bless. Goodbye. See you tomorrow.